All right, joining me right on top is Dr. Abhishek Manu Singhvi. He's a fourth-term MP, eminent jurist, senior advocate, Supreme Court, also a member of the Congress, senior Congress leader. Also, importantly, viewers, he has been the lead counsel in this case where he represented the government of Tamil Nadu. Appreciate you taking the time out, Mr. Singhvi, and joining us. First up, there's been a fair amount of commentary, Mr. Singhvi, on if the vice president was out of line. Many suggest it's a constitutional, largely a ceremonial post. Should he have made these comments?
With the deepest and greatest respect and genuine respect to the Honorable Vice President, my answer is an emphatic no. He is the holder of high constitutional office, second in the warrant of precedence, and there is no occasion, no necessity, no requirement, no obligation to comment on all and sundry and issues like this. Does the President comment on this, Preeti? Have predecessor Vice Presidents commented routinely on such matters? Should the next person in the line of warrant of precedence, the Prime Minister, comment on such matters? My respectful answer is no. I think clearly it was uncalled for, unwarranted, and unnecessary, before we come, of course, to the nitty-gritty of things like Article 142 and the case itself. But certainly, this was not, in fact, it is completely out of sync with the very high position which this is involved in the Vice President's post.
Mr. Singhvi, you had represented the Tamil Nadu government in the Supreme Court, where you had argued that the governor's action violated the constitution. And in its verdict, the Supreme Court had held that Tamil Nadu's governor reservation of 10 bills for president's assent is illegal and had used its extraordinary, powers under Article 142. So in this particular case, if you're going point by point, you had Mr. Jagdeep Dhankar, the vice president, who actually described Article 142 as, and I quote, nuclear missile against democratic forces, which allows the judiciary to act as a super parliament by enacting laws as seen in the case of Tamil Nadu. How do you respond to that characterization, Abhishek Manu Singhvi?
Before I use my own adjectives to deal with those very colorful adjectives you've just quoted, you judge and your viewers judge for yourself. 142, let's just stick to the law first. We'll come to the facts later. 142 was not created yesterday. It was not created for this case. 142 was created by persons far wiser than all of us put together, our Constituent Assembly. It was created by Babasaheb Ambedkar and his drafting committee. It was created exclusively for the Supreme Court. It was deliberately and consciously stated not to be given to any other court in India, including any high court. The idea was that this is a sui generis, special, unique power to the apex court, who is the custodian of the trust of the entire nation, to do complete justice in very, very extreme cases or cases which deserve it from going beyond the mere letter of the law, to implement the spirit of the law, to do complete justice. Secondly, you must remember, Preeti, it is not an uncanalized power. It is not Jungle Raj. It is not chaotic. It is cribbed, canalized, circumscribed, conditioned by at least 20 to 40 major Supreme Court judgments over the 75-year-old journey. It is exercised on criteria laid down in those judgments. So to suggest, all I can say is the missile is probably coming from elsewhere than the Supreme Court. The Supreme Court is exercising its constitutional power. When it strikes down law, when it strikes down executive action, when it strikes down governor's action, it routinely does it in 356, it did it in Bombay. Can you call it a super parliament? I'll come to the facts of this case and make good to you presently how, if at all there was an understatement of the law and the facts by the Supreme Court, everything said there was completely deserved. But as far as the law is concerned, I think this is clearly not justified language for a judgment.
Dr. Singhvi, the fact is you were the lead counsel on this particular case. You've explained the bit on, invoking section or article 142. On the other hand, what many suggest that possibly when it came down to the role of the governor, the top court was correct, but there has been a legal discourse which seems to suggest that when Mr. Dhankar objected to the court setting a 3-month deadline to the president to act on bills, claiming it undermines constitutional role, that is a grey area.
I will come to the precedent in a minute. But the first preliminary question I ask myself and you and your viewers, none of these high constitutional authorities thought it right to comment on or chastise other constitutional authorities who sat on bills for 1.1 years in the case of Tamil Nadu. You are now chastising the Supreme Court. Was it right or wrong for a governor neither to pass the bill, assent to it, nor send it back? So a decision not to decide became a decision. Now look at the other steps before I come to the president. In the first place, you don't decide. And in the first place, while it's pending with you, you do not also refer it to the president. The Tamil Nadu government goes to the court. Immediately, you send it back to the Tamil Nadu government. It requires the Tamil Nadu government to go to court for the governor to refer it back. When the Tamil Nadu government sends it a second time, you know that you are bound, so you refer it to the president this time. When Baba Sahib said that institutions are only as good or bad as the governors or the persons or the man or woman who mans it, this is what he meant. The constitution can't tell the governor everything how to do it. It is the spirit which is being violated by high constitutional functionaries from Tamil Nadu to Bengal to Punjab and many other states. And it is happening particularly in opposition ruled states where you are supposed to be the agent of the central government, as if you are acting as some kind of a, obstruction or barrier to governance. Now let's come to the precedent. The structure of the articles of the Constitution which deal with the assent to a bill by either the president or the governor are identical or almost identical. There is no difference. The only difference arises that the president cannot refer it further to a president. That is the difference with the governor. But as far as the time limit is concerned, if it is kosher to put a time limit for the governor, in what way is an Article 142 misused if the same time limit is put for the president? It doesn't mean that the current president has done anything like that. As a matter of fact, with the current government, to imagine that the president would keep it pending for a year and a half would be unthinkable. But it is not unthinkable for an opposition state like Tamil Nadu. It is not unthinkable for states like West Bengal and Punjab. But in theory, why should a president sit on it? And let me tell you one more thing. The governor who was involved in these 10 bills or whatever, 11 bills, all the bills fell squarely in list 2, which is exclusive state competence. There was no reason to hold it or then to refer it. There were local matters like municipalities or sewerage or this and that. So really, it's the spirit of how you operate the constitution which matters. And when all this is happening under your nose with the governors, why are high constitutional functionaries not commenting adversely on that gubernatorial overreach instead of chastising the Supreme Court? And the office of governor was intended by Baba Sahib. He said there can't be two swords in one scabbard. Ek myan mein do talwar nahi. The chief minister is the governor of that state in terms of governance. And you can't obstruct his governance by keeping bills pending. The same applies to the central government and the president. Yes, I agree that the deemed assent is not written in the Constitution. Yes, I agree that 3 months or 2 months is not written in the Constitution. But if 142 is not used for this, what is 142 created for? Why did Baba Sahib and the Constituent Assembly give this power exclusively as a unique power to the Supreme Court? Only for such situations where governance has been obstructed and stopped by persons who were entrusted with governors. So who will guard the guardians? Who will govern the governors? Only the Supreme Court.
Dr. Singh, last two questions that I'd ask you. The Tamil Nadu judgment has been hailed historic by some, unprecedented also by many. Do you think this judgment is somewhere down the line going to set a precedent or the verdict will shape the state and center relationship, especially where opposition-governed states are concerned?
Before I answer your question, 5 seconds on the fact that people forget what meticulous research, industry, and comprehensiveness went into this judgment. The bench more than once gave us detailed queries, nuances, issues, sought opinion of all, including the Attorney General and our side, got researchers put on each of those issues. A lot of pain and effort went into this. It's not a casual thing on which casual comments can be made. Secondly, absolutely yes, it is already a precedent. It's a judgment of the Supreme Court, which under Articles 141 and 142 is fully binding on everybody in this country, including the highest constitutional authorities. and they are obliged to implement it in letter and spirit. That's what 141 read with 142 means. Thirdly, it is a clear message, a somewhat delayed, much desired, much necessary, vitally necessary message to all governors. You are not Supari agents of the central government. You are not there to obstruct governance. You are not there as a parallel chief minister. You are there to aid and assist governance and be the overall friend, philosopher, and guide instead of being two swords in one scabbard, two chief ministers in one state. I think that larger message is also implicit in the judgment, but I would strongly support every word and the industry and the care and the caution which judgment is written. And unfortunately, I think some of the strong words used as adjectives about the judgment are completely uncalled for, unjustified and unnecessary.
But the Vice President, Dr. Singhvi, did raise, which are shared by many, broader concerns about judicial accountability, overreach or, judicial activism. And on many accounts, be it the large hauls of cash that were found in a judge's house and the kind of action, that was taken, or even you've had the speaker or, the former law minister Kiran Rijiju speak about the NJSC verdict or the collegium. So he has raised broader concerns, which many are speaking of today.
First of all, with greatest respect, unfortunately, there is no connectivity in speaking in the same breath about this judgment and the episode involving Justice Verma. You can't begin to connect the North Pole and the South Pole for no reason at all. I don't understand how one reflects on the other in any remotest manner. It was equally inappropriate to link them. I'm saying so very clearly. Secondly, everybody knows that there is a procedure established, not created yesterday for you or me or for Justice Verma. An in-house procedure has been in operation for decades. It is under that procedure that the Chief Justice of India has taken steps. 3 vice persons, 2 chief justices and 1 lady judge of seniority are looking into it. The report will be out soon. Why should we suddenly change that procedure? Had that procedure not been followed by Yashwant Verma, is there any other law which the Honorable Vice President would want us to follow? How can you hearken to a system which is in existence being followed versus a non-existent system of no other system is available to do this? Yes, if you pass a law in future for these matters to go short of impeachment to the parliament, then that will be the law followed. In fact, I was chairman of a committee way back in 2011, a parliamentary standing committee, which recommended the Judicial Accountability Bill that never became law. But till such time, it's the only in-house procedure which will govern. And lastly, it is not the time and place because the whole comment was on the judgment. It has nothing to do with the Yashwant Verma episode. But let us not be, let us hasten slowly. Let us not use a push-button system that Yashwant Verma episode means push-button and lo and behold, by a magical wand, you have NJSC and all these ills vanish into thin air because of this magical wand called NJSC. Please don't use one to implement the other. Please don't use one to further some agenda which is other than relevant.
All right, Dr. Singhvi, appreciate you taking the time out and joining us this evening. Thank you there.